of OCGA 16-5-1 subsection C, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 4, and the grand jurors aforesaid, in the name and on behalf of the citizens of the state of Georgia, charge and accuse Suzanne Mericle with the offense of aggravated assault. For that, the said accused in the county of Hall in the state of Georgia on the 8th day of March 2025 did assault another, to wit, James Barron, with a deadly weapon, to wit, a firearm, which when used offensively against a person is likely to and does result in serious bodily injury by firing said weapon through a door in the direction of James Barron in violation of OCGA 16-5-21, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 5, and the grand jurors aforesaid, in the name on behalf of the citizens of the state of Georgia, charge and accuse Suzanne Mericle with the offense of criminal damage to property in the first degree. For that, the said accused in the county of Hall in the state of Georgia on the 8th day of March 2025 did knowingly and without authority interfere with a door in a manner so as to endanger human life by shooting the door of a room that was occupied by a person, to wit, James Barron, in violation of OCGA 16-7, again 16-7-22, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 6, and the grand jurors aforesaid, in the name and on behalf of the citizens of the state of Georgia, charge and accuse Suzanne Mericle with the offense of possession of a firearm during commission of a felony. For that, the said accused in the county of Hall in the state of Georgia on the 8th day of March 2025 did have on her person a firearm, to wit, a handgun, during the commission of a crime, to wit, aggravated assault, as alleged in count 4 of this indictment in violation of OCGA 16-11-106, contrary to the laws of said state, the good order, peace, and dignity thereof. The last count, count 7, and the grand jurors aforesaid, in the name and on behalf of the citizens of the state of Georgia, charge and accuse Suzanne Mericle with the offense of tampering with evidence. For that, the said accused in the county of Hall in the state of Georgia on the 8th day of March 2025 did knowingly conceal physical evidence, to wit, shell casings and bullets, with the intent to obstruct the prosecution of said accused in violation of OCGA 16-10-94, contrary to the laws of said state, the good order, peace, and dignity thereof. The defendant has pled not guilty and denies each and every allegation therein. Please understand that these are only accusations, and the state has the burden of proving their case beyond a reasonable doubt. The defendant has no burden to prove her innocence. The defendant is presumed innocent unless it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the crime or crimes charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime or crimes charged beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It is a doubt of a fair-minded, impartial juror honestly seeking the truth. It is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given arising from a consideration of the evidence or lack of evidence, a conflict in the evidence, or any combination of these. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to prove her innocence. If, after giving consideration to all the facts and circumstances of this case, your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you should acquit the defendant. But if no doubt exists in your minds about the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. During the trial, I may be called upon to rule on motions or objections. This is normal, and the lawyers are just doing their jobs. If I sustain the objection, you shall not consider the limited portion that was part of the objection. If I overrule the objection, you may consider that limited portion that was part of the objection. Please note that nothing I say in making these rulings or at any time during the trial is evidence and should not be considered as an indication that I have any leaning in this case whatsoever. My only interest in this case is to see that it is fairly tried according to laws and the Constitution of the state of Georgia and the Constitution of the United States. Trial procedure in a criminal trial is generally as follows. First, the attorneys for both sides have the opportunity to present opening statements. This opening statement is not evidence, but is a preview or an outline of what the attorneys expect the evidence to be. Following the opening statements, evidence will be presented. Evidence can be in the form of testimony given by witnesses or physical evidence. After the presentation of all the evidence, the attorneys have the opportunity to make a closing argument. The goal of a closing argument is to persuade you to decide the case in their favor. Following the closing arguments, I will charge you more specifically on the law that applies to this case. I will then ask you at that point to retire to the jury deliberation room and reach your verdict. The jury has a very important role. It is your duty to determine the facts of the case and apply the law to those facts. I will instruct you on the laws that apply to this case, but you must determine the facts from the evidence. It is important that you pay close attention to the evidence as it is presented during the trial. If at any time you are unable to hear or see any of the evidence being presented, or if you're uncomfortable, please let me know or one of the bailiffs know. It is important that you view the evidence with an open mind at all times and reach no final conclusion until the trial is over. Y'all have been provided pens, paper, pencils. You are not required to take notes. If you choose to take notes, you can certainly do so. Please understand each member of the jury is responsible for their own recollection of the trial. No one's notes are better than anyone else's. Certainly, y'all can make determinations as far as deliberations goes, but please understand that you're not required to take notes, but if you want to, you certainly can. After the trial is over, the notes will be collected and destroyed. Please keep an open mind and reach no final conclusions until the trial is over. You must decide this case for yourself solely on the testimony you hear from the witness stand and the exhibits admitted into evidence. Do not visit the scene. Do not conduct any legal or factual research. That means in person, online, good old-fashioned books, AI, Google, none of that stuff. What you will learn about this case, you will learn about in this courtroom only. Until you retire to deliberate, you may not discuss this case with anyone, including family, friends, even your fellow jurors. After you retire to deliberate, you may begin discussing the case with your fellow jurors, but you cannot discuss the case with anyone else until you have returned a verdict and the case is at end. This concludes my preliminary instructions, and in a moment, we will start with the lawyers giving opening statements. I understand that this matter has received some notoriety. There is an official rule called Rule 22, Uniform Superior Court Rule 22. It governs photographs, videos, etc. of proceedings. We've had approximately 7 requests from various media outlets. I've signed them all. I respect the First Amendment rights of our press, and I very much respect the open court system. I think it is a very, very valuable part of our democracy. That being said, if you have not filed an appropriate Rule 22, again, I've signed every single one. If you've not filed one and you raise your phone up like you were going to take a picture, whether you're a civilian or whether you're from the press corps, we will have a separate and distinct conversation which may result in potential contempt of court and incarceration. I'm not doing that to be mean. We're going to follow the rules. And the rule is, if you filed a Rule 22, fantastic. I've signed every single one of them. If you have not and we have a problem, then we will have a problem. Additionally, I have, as judge, I've guaranteed the state 10 spots. I've guaranteed the defense 10 spots. If you are in one of those 10 spots, you do not have to move for anyone. If anyone is in your spot, you let one of the bailiffs know, you let one of the sheriff's deputies know, and if need be, let me know and I will resolve the issue. Each side is allotted 10 spots. We have plenty of room right now. I don't think it's going to become an issue, but if it does become an issue, let's not have it become an issue. So if you have 10 spots, they're your 10 spots, feel no obligation to move. With that being said, state, ready for your opening statement?